we're good to go.
Thank you very much. Welcome back, everyone, to the resumption of hearing 14 of the New Plymouth District Plan review hearings. I'm quite like to start with a karakia. So would one of the mana whenua like to kick us off with a prayer? Would be appreciated. If not, Antoine. Yeah.
Tēnā koe. Tēnā koutou, tēnā tātou. Ko Glenn tēnei. E mihi ane kia koutou i te rangi nei, te rangi paki, ki waho i kei Taranaki, anō reira kei te mihi, kei te mihi. Maku ka tuku kareke, hei whakapai tā tātou ara i te rangi nei, tā tātou kōrero, kei te mihi. Kia whakaronga ke au ki te tangi a te manu nei a te mātu. Tui a. Tui ai runga, tui ai raro, tui ai waho, tui ai roto, ka rongo te pō, ka rongo te ao. Tui e te moka tangata i take mai a waiki nui, waiki rua, waiki pāma māta kona ki wairua. Unu hia. Nō reira, kei te mihi. Haumi e hui e, ai ki e. Tēnā koutou.
Kia ora.
Sure. Thank you very much, Glenn. So I'm pretty sure that everyone online has been involved and has had the introduction to this hearing. So we do have very specific time limits on these next 2 days. Commissioner Coffin has some other engagements, and we've planned for these 2 days to get through the discussions. So look, I think unless there's any questions, we'll just get straight into the hearing. And I will start with just noting that we have been requested by 2 parties, Glenn, yourself, and I think Joe Healy, to have party evidence to heard under an order of sort of in confidence. And I'll just ask you to guide us through which parts you'd like us to certainly hear. Our order, which was issued under a minute, is that council staff and advisors and the Hearings Commissioner can hear that evidence, but no other public, unless obviously there's a support team around you, Glenn and Joe, tomorrow that you're happy to listen in. So we'll just look at who's online at the time and make some orders in. So with that, any questions on any of that? All right, Keith, you've given us an updated statement, I think, so the time is yours. Welcome and thank you very much for your submissions.
Thank you very much, Mr. Chairman, Commissioners. Good morning and greetings to you all once again. Kia ora whānau. My name's Keith Holswich and I've been tasked by my hapu to represent them during these proceedings. I note that Mrs. Marsh is not yet signed in. She's currently on site at EPR Road. She is trying to log in, but is not there at the moment. So I put my apologies in for Mrs. Marsh. So I understand that you've got my revised speaking notes, revision D, and I'll be reading from those. And you would have noticed that while our submission on the section 42A report is rather brief, our supporting documents are rather long. And if you've managed to get through more than half a dozen pages, thank you very much. But we felt we had a story to tell, and now seems to be the right time to tell it. We appreciate that some of our story may be out of scope. It's important to include so that you can all understand where we're coming from on this matter. At our first hearing, we were quite complimentary to council, and deservedly so, in their efforts to generally involve us in their processes. However, quite clearly on the sites of significance matter, we are scathing in our submission about the processes we have encountered with council over the years. This is not directed at the individual council officers we have dealt with, but at the institution we call the New Plymouth District Council. There is this painstakingly slow institutional wheel that appears unable to process information or processes that over the years is slowly grinding us down. We have for the last 25 years or so heard wonderful words about how our sites will be recorded, protected and managed. However, very little has been done, and we're still hearing the same old words being spoken today that we heard all that time ago, and this is rather disappointing. Someone or some group in this institution of council needs to take this matter by the scruff of the neck, wring it out, shake it, own it, and as the advert says, just do it. At the moment, it is not working. Paragraph 6, our submission then is in two parts. Part 1 being our very brief response to the section 42A report, and we call this as where we want to go section. And part 2 being our very long background information and appendices, and we call this where we have been section. I'd like to start, if I may, with part 2 of our submission so you can understand where we're coming from. This is where we have been. Paragraph 6 to 12 discuss our disappointment at being left out of the site identification process. We note that we cannot understand council's reasoning for this and simply suggest that they have dropped the ball. And here's why we're upset. In 2014, when we participated in Plan Change 43, over which Commissioner Coffin expertly presided, the criteria for site identification was certainly different than today. The inclusion of any site then depended most certainly on archaeological evidence. And we all recall the hilarious situation of our archaeologist, Dr. Barter, and council's archaeologist, Mr. Dan McCurdy, arguing about whether such archaeological evidence existed or not. Many of our proposed sites at that time were kainga, that in the olden times were refuges in the bush in times of conflict with our marauding northern neighbours. They were secluded garden spots, or they were used as resting and stopping off places when travelling down country. Unfortunately, and contrary to the submission from Ms. Walker of Federated Farmers, cultivation and ploughing over the years has obliterated any above ground archaeological evidence of these sites. And as our cultural evidence at the time was not particularly considered, many of our sites were left out of Plan Change 43. It appears, sir, that there's been a quantum shift in council's thinking this time around, and a far greater emphasis on cultural values that have now been taken into account. And this is great. The point of all this is that we as a hapu were never given the opportunity to be part of the site consultation to address this most vital matter. We note the graph shown by Ms. Chamberlain at the start of the hearing that showed our hapu as being 100% complete with 91 actual sites. How can this be when we have been prevented from being involved in this process? We estimate our completion as being closer to 0%, with over 100 actual sites to be reviewed. In Appendix 1 on page 6, and if I can ask you to look at that, sir, we have got a map of our rohe. This is previous.
I wonder whether we could just bring that up. Do we have that handy? Julie?
Appendix 1 on page 6, Julie.
So if this is your speaking notes, Keith?
No, that'll be on part 2 of our submission.
Your submitted evidence or your original submission?
Submitting evidence.
Thank you. I will just find that.
Thank you, Julie. If I may continue, this our Rohe map has previously been presented to you, but now we have shown indicative areas of where our sites of significance are. The importance of this map is not the number or distribution of the known sites, but the vast expanse of land that is yet to be investigated and may contain historical and cultural sites, especially along the coastal and Tikarangi areas. And so we mention that because later on we'll be talking about how are we going to identify sites and areas of significance that are not yet found. In appendix 2 on page 7, our hapu member Tomarangi Marsh, MA, discusses her views and that of our hapu regarding the concepts of Maori heritage from a Maori epistemological framework. I can't even pronounce the word, sir, and I must confess that much of what she has said is over my head, but she was given the opportunity to express our views on our heritage, and I think she's done a wonderful job. Unfortunately, she's not available today to come to this hearing or to be cross-examined, so this information is included for your review only.
Keith, could you just pass our thanks on to Morangi for her work here? Obviously, it's a really interesting body of work, and we do appreciate this being provided to us.
Thank you, sir. Yes, I will do that. In appendix 3 on page 9, our archaeologist, Dr. Hans Bader, discusses his views relating to the difference between removing archaeological sites as opposed to removing sites of significance from the district plan. And we note here, sir, that Greymouth no longer wish to pursue site removals, and we thank them for that, but it should be noted that we do agree with the views of Dr. Bader. Unfortunately, Dr. Bader also couldn't be at the hearing, but I think, sir, as Greymouth have withdrawn their application to remove sites, there's probably no questions for him. In appendix 4 on page 10, we discuss the hurdles faced in trying to add additional sites to Schedule 3 and the E-Plan. We're advised that the RMA is the biggest obstacle to streamlining the process to add new sites, and so we suggest ways that this can be circumvented. They're pretty practical ways that probably can't be done, but we've just simply set out how we think things should happen. And it should be noted that any references we've made in this appendix regarding any particular planning geek to help us does not necessarily refer to anyone on the hearing panel. On appendix 5 on page 11, we discuss the rather crazy conundrum where we are trying to put in place wonderful mechanisms for the protection and preservations of our sites through the proposed district plan, yet external consulting authorities, such as Heritage New Zealand, can issue permits for the damage, destruction, and desecration of our sites, whether scheduled or identified or not, most often without actually knowing where these sites are or what they are. We find that absolutely nuts. As a case study, we present the Greymouth Petroleum Turangi H well site at the end of Epiha Road, Motunui, and we understand that the commissioners may have recently visited that area.
Yes, Keith, that's correct. We were taken there, and we did actually have some discussions with the orangatahi who was there helping on the site. Can't recall his name, but also the archaeologist came and had a chat to us as well.
That might have been Selwyn, sir.
Yeah, I think it was, yes.
Julie, if you could please bring up the map on page 14 of our same submission there.
Let me just flip that for you. That one there?
Thank you very much. So as you can see, the Turangi H well site snugly wraps itself around the 50-metre buffer zones from existing sites, making full use of the operative district plan provisions to the maximum. Clearly, the operative district plan rules, no matter how well intended they are not able to protect the site from being destroyed. Also, quite clearly, the plan shows that a blanket 50-metre offset distance from a particular site did not work in this area and in this situation. It appears that something more than a simple distance is required here, and a much more thorough investigation into the surrounding cultural landscape is required prior to any design works or consenting being carried out. And in this particular case, Mr. Dan McCurdy did carry out an initial investigation, advised Heritage New Zealand and Council that there was every likelihood that a site of significance would be found, yet a permit was issued to destroy the site. So something different must be done. If we are serious in protecting our historic sites, including those yet to be scheduled, then certain matters should be considered. And we include totally removing Heritage New Zealand from the equation. We say, get rid of them or make their actions subservient to the operative district plan. We then suggest setting up a traffic light system such that firstly, we look at a 50-metre offset distance from a particular site. If there is considered to be evidence of something there, then a cultural landscape is considered, perhaps up to 200 metres away from any site. And finally, a thorough ground penetrating radar survey is carried out. And all of this should be done prior to any design or consulting works being carried out. And if anything is found, the proposed development must be moved to another location. It's as simple as that. In this way, the protection of our sites yet to be discovered may be protected. In Appendix 6 on page 15, we present a case study and discuss the pitfalls and offer a solution of how any possible development within the extents of or within 50 metres of a site of significance on Maori purpose zone land may be dealt with. We express our concerns that any such development in the proposed district plan will be a restricted discretionary activity, invoking the dreaded affected party participation. We note our supposed rights under the Treaty of Waitangi that guarantee us the undisturbed possession and enjoyment of our lands, and we highlight case law that applies to such matters. We believe that no third party should have any say in what we as tangata whenua propose to do on our traditional reserved lands. There are two possible solutions here, being one, allow us as owners to utilise and develop our lands without interference of any third party. In other words, make all such activities permitted, or retain the restricted discretionary activity on the site, but deny interference from any third party. We're quite happy to comply with council's rules. We don't want neighbours or third parties to come and tell us what we should be doing on our land. And of course, we note strategic objective TW11, where we as Tangata Whenua are able to protect, develop and use our land in a cultural and traditional way. And we cannot do that if we have interference from so-called third parties. We are just simply expanding on the strategic objective. Julie, if we can go to page, Julie, can we go to page 16 on my topographical map, please? And turn that sideways. This is not in my speaking notes, sir. This is a topographical plan that I produced a couple of years ago for a proposed Maori site on our reserve lands. It is totally within the extent of a site of significance. It's within 50 metres of an urupa. It is a place where we believe a Maori site could be established. Again, why should any third party have any input into where we should be able to put our marae on our land just because it's a restricted discretionary activity? And we respectfully ask that this matter be seriously considered, but we'll leave the implementation of such policies and rules up to those that know what they're doing. We're not the experts in this, sir. We don't know the proper wording. We would rather say, let us do what we want to do on our land. In paragraph 14, we call Appendix 7 on page 17 a road to disaster. In this appendix, we highlight what we think is the disastrous encounters we have had with council over the last 25 years or so when dealing with our sites of significance. This appendix is added simply to get such matters off our chest and to present the background and reasons of why we as a hapu are so disgruntled with council over the handling of the sites of significance matter at this time. It appears nothing has been learnt. We note that Commissioner Coffin has been asking other groups what their experiences have been throughout this process. Sir, ours are highlighted here. We note that even at the time of finalising our submission to council on Monday, the 24th of January, there was still no definitive Schedule 3 listing of the sites of significance within our rohe. Indeed, at the time of writing these speaking notes, we still do not have a final copy of Schedule 3. We cannot and will not approve Schedule 3, either provisionally or finally, until such time that we are satisfied our sites have been correctly identified and shown in the E-plan. And as I've said, we consider council's relationship with us over this matter to be truly a road to disaster. If I can move on to other matters, and in paragraph 15, we're not sure where or when we are to discuss the deficiencies of the council GIS system. We think it's perhaps in the final wash-up chapter. We just note here that any suggestions we have tried to make to improve the system, we are told, cannot be implemented due to operational constraints. I can only suggest that council then are using the wrong GIS system. We as a hapu determined many years ago that council was never going to be able to process, protect and display the information we provided them. So started up our own GIS system that corrects any of the problems that council have. And we decided therefore that our GIS system will and must take preferences over council's. And we will only use council's system to provide a trigger for anyone to get in touch with us. So this is not an ideal situation. It's been forced upon us. And on this GIS matter, we were rather surprised and annoyed to find out on the first day of the hearing that Mr. McCurdy And we must say that he's done a wonderful job in identifying the very large number of sites. He advised that he had much significant site information stored on his office computer and was concerned what would happen if he was hit by a bus. On our checking, it appears all hapu iwi groups knew about this situation except us. On further checking, we were advised that some of our information was indeed included on Dan's computer. I'm not getting at Dan here, as him and I go way back, but he should not have any of our data on his computer. And here's why. When we embarked on the site upgrade journey in 2008, we were concerned about many matters based on our previous experiences with council. And these included that our data supplied should be kept safe and secure within council, that no one should be able to alter or amend our data without our permission, that council would not sell or supply our data to any third party, and that sensitive information should not be made public. And this was agreed to by our signed 2011 contract with council, who said none of this would happen. We found out the other day it has. So what are we to do with the signed council contract now that has been broken by them? Throw it away or keep it as a memento of broken promises? And I'm sure, Mr. Chairman, that Frank Versteeg, who was the council's general manager of consents and planning when he signed this contract with us, would be extremely disappointed to know that there is now a breach of that contract.
Do we have a copy of the contract in the evidence, Keith?
No, we don't, sir. I can pass it on to you if you like.
Yes, just through Julie, thank you.
Sir, my apologies for getting a bit off topic, and really this need not go any further, but we highlight this to show that even today, the actions of council speak far louder than their words, or indeed their contracts. While we wish to keep a constructive dialogue open with council, they are certainly making this very difficult. And Mr. Chairman, if I may, I'd like to take the opportunity to comment on a few other matters that have been raised during the hearing. And I think this is the benefit of speaking last, as you get to hear other people's comments. In the first matter, Ms. Jo White of Manukurihi mentioned her concerns about other hapu names being added as manawa whenua on their sites. We also have the same problem. And when we approach council for an explanation of this, we are advised that if any group or hapu claims mana whenua over any site, their name would be added without question or hesitation. We were astounded to find out this, especially as we've been advised that no alterations would be made to our data without consultation with us. In the end, though, such matters are for the hapu to sort out between ourselves and not for council, so this process must be stopped immediately. And through you, Mr. Chairman, I'm sure Commissioner Coffin will understand our joint concerns over this matter of people adding mana whenua status over our sites. Matter number 2, there's been some discussion about silent files and how they are treated within the framework of significant sites. And perhaps if we can explain our process. When a sensitive site is identified to us, the first people to be advised are the landowners, where the location of the site and the significance of the site is explained to them. Then and only then will we add the silent file as a property on the council system. Within our own GIS system, we have all the details, including the stories and the photographs, but council do not get these. We don't trust council to look after them. And as an example of this is how Mrs. Walker from Federated Farmers called not so long ago to confirm there had been no change to the silent file status on one of her clients' properties. This system works well for us. We have another site where the landowner will only deal with us as a hapu and no other group, so has agreed to keep the silent file specific to us. Again, neither council nor any other group know what the site is. We do, and the landowner does. And we have landowners and very good corporate citizens who actively encourage whānau participation on some silent file sites, realizing that public knowledge could damage the significance of these areas. In summary, the silent file option is one that we would like to keep as a very useful tool for site protection. And may I say, sir, that with council allowing other hapu mana whenua status over our sites on demand and without consultation with us, we have informed council that in future, any site we rediscover within our rohe will only be added as a silent file to stop this from happening. This is nonsense. It's a nonsense situation that has been forced upon us by council. Matter 3. There's been much discussion regarding cultural landscapes rather than individual sites or even clusters of sites, and how such landscapes can be shown in the council GIS system. To us, this was a very simple matter to produce in our GIS system, as we showed during the Energy Hearing 12 and how we dealt with seismic surveying. And we did include an indicative map of how we showed rings around our sites. We noted that 90% of our sites of significance are within 150 meters of a waterway or the coast. So we simply placed a buffer area around the rivers and streams and around our sites, pressed the appropriate computer button, and voila, we have a cultural landscape within our rohe that contains by far the majority of the areas of concerns we have. We simply ask, if our GIS system can do this so simply, why can't councils? The layer could then be a non-regulatory advice layer that will alert all users of the plan that something is likely to be found within that zone, or that tangata whenua have unverified concerns about the area. We use this all the time and it works well for us during consenting processes, so I'm convinced it will work for others as well. Matter 4. The comment with respect to Ms. Chamberlain's explanation that some of the delays in the site identification process were due to the number of Lagoima requests that had to be dealt with. I can advise that as we as a hapu could get nothing out of council with respect to our sites, we found it necessary to put in a Lagoima request ourselves to try and find out what was happening. It took 2 months for council to respond to our Lagoima, but how dumb is it that we've reached a situation that this was the only path we could go down to get to talk to council? But it worked, Mr. Chairman. We actually did get to meet with council for the first time on this project a month ago. To sum up our relationship to council, the whole business is best described as a disappointment. Sir, with your indulgence, I'd like to raise one other matter that is not addressed in our submission or our speaker's notes, but was brought to my attention last night. And I think it's an important one, if I may continue.
Of course.
Thank you, sir. I'm happy to pass this on to you when I'm finished. It's something I've just written out this morning. In 1998, Fletcher Challenge Energy announced they wished to drill from land adjacent to one of our sites of significance, in this case in Urupā, then under our Urupā out to sea to their prospect. They noted that the extents of a site of significance in the operative district plan was 50 meters and took this to mean that was vertically as well as horizontally. They also noted that as they were going to be 1 kilometre or so under our Urupā when they drilled, there would be no problem. We of course said, no, you can't. They of course said, yes, we can. So this matter, along with many others, became the subject of an environmental court case. And that court case number is RMA 292/98. And that court case was between us and many others against the New Plymouth District Council, the Regional Council, and Fletcher Challenge Energy. The under-drilling matter was duly raised at the court hearing. Fletcher Challenge called their iwi liaison officer, Matua Lindsay McLeod, to stand to discuss this. And I note that prior to Lindsay being the iwi liaison officer for Fletcher Challenge, he was the council iwi liaison officer. He was a very well-known, knowledgeable, and respected gentleman. No one who was present at the court that day will forget the response Matua Lindsay gave when he was asked the question of how far up or down did a site of significance go, and was it only 50 meters? With a huge amount of passion, he authoritatively declared that the extents of such a site extended, and I put this in quotation, extended from the heavens above to the center of the earth. That was his words. Mrs. Marsh, although she's not here, she will recall that when he said that. As we totally agreed with his interpretation of this matter, there was no further questions nor discussions. And in this case, Fletcher Challenge deviated their drilling route so as not to go under our urupa. The issue we now have is that to us, this principle has been and still is our position: no drilling under sites of significance. In this case, our po is in the land, our stake is in the ground over this. But it was quite rightly pointed out to me last night that although this may be our norm, such a situation is not covered anywhere in the proposed district plan. And indeed, we have never raised this matter before. The question then becomes, how can we enshrine this particular matter into the proposed district plan? I suspect we've missed the bus on this, Mr. Chairman, and we're too late to include any new policy or rule to cover under drilling of sites. But could there not be a note in the overview section that simply states, in our world, the extents of a site of significance, and in the words of Matua Lindsay, extend from the heavens above to the center of the earth. By this simple statement, we shall cover ourselves from unscrupulous developers who may wish to drill under our sites of significance in the future.
Keith, is Maya Wakaira, we're hearing some legal submissions from her tomorrow. Is she acting for Ngāti Rahiri as part of the collective legal advice?
So we have been rather independent of this process, looking after ourselves. So if she wants to raise that, we haven't been in discussions with her. I know her well, but we haven't been in discussions with her.
Yes, it's something that we will, like my understanding, and I'll be corrected by the lawyers, certainly there is common law about those matters. So it is a legal point worth just touching on, I think. So we'll make a note to ask Sarah. I see you've popped up, Sarah Marco.
Tēnā tātou. I can ask Maya to cover it off if there's something that you do want her to cover off before tomorrow.
Yeah, I think that this point about the extent of jurisdiction of district plans, sort of upwards and downwards from the land surface, would be, I think I know the answer, but I'm not going to say what I think. So, I'm not a legal expert, obviously. Yeah. Thank you, Keith, and you'll put that as that statement in as an addendum through the written statement through Julie about that matter.
Yes, indeed, I will. Thank you very much. Good morning, Mrs. Marsh. I see that you've popped up on my screen. Again, sir, I sincerely apologise for the lateness of bringing this to your attention. As I mentioned, we consider this the norm, and it was something that we hadn't even thought of talking about. And I take full responsibility of leaving this most important matter out of our submission. If it's taken up by others, thank you very, very much.
Well, just to be clear, Keith, as a lay submitter, we hear what you have to say on the day. If you've, in your case, you've presented some very, very clear and well-written submissions, but it's, I think it's clear to us that you can bring to the attention through verbal information like you're doing today, these sort of matters. So there's no problem from my perspective.
Thank you very much, sir. And that's the end of our discussion on our part 2 submission, and that's where we've been. I'm happy to take any questions, or we can carry on to our part 1 of the submission, which is very brief, dealing with the Section 42 report.
I think we will pause and just take any questions from the commissioners on your part 2, starting with Commissioner Coffin. Antoine, good morning.
Hey, good morning, everybody. Tutahi māku e miana kia koe Glenn, tīmata i tātou hui i tēnei ata o tira he mihi kawana ki ngā pautoko manua ngā hapu o tira o ngā iwi. Just acknowledging Glenn starting us this morning and those who have joined us online. O tira he whakaro pai kia koutou katoa I noho ana I tō kāinga, and just good thoughts to you all sitting in your respective homes. It looks like most of us are working from home this week. I just had a few questions in regards to the part 2. The first one, Mr. Holswich, is just in regards to the process for identifying mana whenua in the plan. From my observations, it's quite a useful way of being able to identify for landowners who may be affected by a site or area of significance to Māori. Who do they need to go to? That seems to be quite a useful trigger. Would you agree?
Absolutely, but the point we were making and Mr. White was making is that we as hapu identify our sites, and that's the mana whenua. We've identified the sites, but council are allowing any other group or person to add their names later on. And so absolutely there should be mana whenua status. Yep.
Yes, I just wanted to double check. You see that identification as a good thing.
Agree with that.
Did you have any particular ideas? I've certainly got ideas, but it's not my submission, it's your submission. What would be an ideal process, or have you got some options that the council might consider for a way of working through that sensitivity of identifying who are the mana whenua for a particular site or area of significance?
What we suggested 10 or 15 years ago, and I know it takes a long time to get anywhere, is that if we identify our site and somebody else wishes to be involved, then we sit down amongst ourselves as hapu or iwi and discuss that matter and give the results to council.
Yep.
It shouldn't be for council just to say, okay, you want to be mana whenua? Absolutely, put it on the list. That's not the contract we have with council. And that's the contract that I'll be sending through to you all.
Okay, thank you. My next question is around, you mentioned Pouhere Taonga Heritage New Zealand. As it happens, I sat on the Māori Council for 3 years and I was a member of the Archaeological Committee. So I do understand some of the frustrations around a central institution that's making decisions in Wellington about heritage that's very specific to place. So I can acknowledge and understand the frustrations with that. I suppose this is more of a statement than a question, Mr. Holswich. I'm not sure that we can, even if we wanted to, ignore the role of Heritage New Zealand and its statutory responsibilities and obligations it has in its statute, but also in the Resource Management Act. So I think we've heard you loud and clear in that regard, but I'm not sure that we'd be able to give the relief that you're seeking, which is take out references to Heritage New Zealand ignore them, etc., etc. And I can see you're smiling, so you know where I'm going with this.
Yes,
So
sir.
I just want to, I suppose I'm managing your expectations around us going and saying, yes, Mr. Holswich, we agree with you, and let's do that. I'm not quite sure that's going to be the case.
No, the Commissioner, I think it's the case of us throwing something in the ring and seeing what happens. We know that there's legislation there. I just hope that Heritage New Zealand is listening in and can understand our frustrations.
Yeah, but certainly I think you also highlighted for us that even though the district plan in this regard is one of the primary tools for protection and management, it doesn't always work like that. And I think it's fair to say there are a number of other mechanisms that may provide legal protection, like covenants, and ultimately the purchase of land is, I suppose, is the ultimate way of protecting a site, is purchasing a site and having it either in the hapu or iwi's ownership or in the public ownership. But there's a number of other mechanisms. I think there was a point well made, even though best attempts are to use the district plan as one of the primary tools for protection and management, that doesn't necessarily apply in all cases. And I thought that was a point well made.
Thank you. I agree with that.
My last one is a question. It's just regards to the silent files, and you've mentioned that you think that process works, where you hold the information and you have the ability to just share that with the landowner. And I suspect that works for sites that are both within the schedules of the plan. Then I think there's about 9 of them from memory, where it says silent file. But obviously there's also a number of sites that aren't in the district plan that also are sensitive sites to you, and you can decide whether you want to share that information with the landowner. Is that the case?
We always share the information with the landowner.
Yes.
So if there's, for example, a burial on their property and we know the history of that, the landowner is the first person to be told. They know exactly where it is. And I think I mentioned Miss Walker from Federated Farmers. The landowner in that case knows exactly where the burial is. Nothing has changed, and we live our lives. It works. As long as you've got that good landowner relationship, and thankfully for by far the majority of the landowners in our rohe, we have got that relationship.
I suppose more specifically, does that also apply to those sites which aren't included in the district plan, where you've decided to have a direct relationship with the landowner without having to have the site in the district plan?
I don't think we've got any direct sites with the landowner with it not being in the plan. Okay. I think that plan is the ultimate protection agency, if you like. So we will tell the landowners, but we will put their property with their permission into the district plan.
Okay, thank you.
We would rather do it that way than to keep it silent, if you like.
Okay, thank you. Thanks, Mr. Chair.
Yes, thank you, Antoine. David?
Yes, thank you, Stephen. Good morning, Mr. Holswich.
Good morning.
And you can hear me okay?
Absolutely.
Great, thank you. The key theme that's coming through for me, Mr. Holswich, from your very clear presentation, particularly in your speaking notes, is there's 2 issues here. One is the known sites, and the second is the unknown sites, and what the regime should be for those 2 types of sites. So I'm just going to split my questions into those 2 divisions, if you like. For the known sites, I had read with interest the process leading up to Plan Change 43, and I think it's companion Plan Change 40, around about 2016 and 17, and you've referenced that and Commissioner Coffin's involvement as the hearing commissioner on that. At that, and I get the impression that you and the Rohe were reasonably satisfied with that process. Is that the case?
Happy with the process, happy for the time that was given to us, a bit disappointed in the outcomes, especially with the number of sites that we wanted to include but couldn't because of lack of archaeological evidence.
Okay.
But quite happy with the processes that we used.
That was okay. You've sort of run to my next question, and that is, were there sites, known sites that weren't included in that plan change that in your view should have been?
Yes, I think there was about off the top of my head, perhaps 6, 8, 10 sites
Yes.
that we could not include. These no archaeological evidence at all.
Yes.
We know they're there. We had the history. We've got the survey maps that show the sites were there, but we couldn't add them. And as Mr. Coffin previously said, there was arguments between archaeologists about whether there was archaeological features there or not, and we
Yes.
all just stood back and smiled while that went on.
Yes, thank you. I'm glad you've been able to.
Just butting in here, Chris held up a number 4. Chris, do you want to just sorry to interrupt, David. I just saw Chris there. Do you want to just update us on that, Chris?
There is specifically 6, but there were only 4 that we were majorly concerned about.
Yes.
Yeah, so 6 to 4.
Yep, thank you. Thank you. Carry on, David.
No, that's fine, Stephen. Thanks for that. That's good to have that clarification. Since that time, the plan change being considered and determined, and the ongoing review process that you've identified in your Appendix 7, and incidentally, Mr. Holsworth, are you the author of the paper A Road to Disaster?
Yes, sir.
Yeah. Okay.
That was my personal experiences with council over the years.
Yes, thank you for that. Appreciated reading that. I'm just a little bit bemuddled as to why there hasn't been any particular consultation or involvement in relation, given the what seemed to be a good process leading up to the original plan change, why there's been a gap between then and the preparation of the draft plan, the notification of the proposed plan in that 5-year period.
From my understanding and discussions, I think there was a couple of matters. One is that council believed that because we had gone through plan change 43 process, that we were satisfied and there was nothing else to do.
Okay.
That's despite the numerous telephone calls, emails and personal comments we'd made over the period to say, no, we did have additional sites.
Okay.
But it's also, it appears as though council have been, thinking of the right word, overwhelmed by the amount of work that had to be done on this project.
Okay. The reason The reason I asked that question is obviously, and you've alluded to it, and we've heard from it from other iwi speakers over the first 3 days of the hearing, that there has been engagement with other hapu and rohi in terms of no-one sites, at least anyway, in that period, and there's been inclusion of additional sites from those iwi in the plan, albeit that those submitters have also indicated that the quantum of inclusion may not be to their liking, and there's some issues with the extents surrounding those sites. So it just seemed that there was a disconnect between your experience and the experience that we've heard from other iwi.
Absolutely, sir, and it's just us. I've spoken to all the other hapu and iwi. They've all been contacted.
Okay.
And I've offered to step aside. If it's me personally that's causing a problem, I've offered to step aside.
Right.
I just can't understand it.
Sure. I'm going to leave that particular matter there because obviously there's an opportunity for council staff to come back and respond to that matter. But I just wanted to set the scene for them.
Yep. So
that's the known sites. What I'm hearing is that the quantum isn't there. There are gaps. And do you have a feel of? I mean, obviously you gave me an idea that the magnitude with the assistant of Ms. March was between 4 and 8 sites back in 2016. Do you have a feel for the magnitude of the known sites that are not in the plan now? Has it grown considerably with additional knowledge?
I spoke to Mrs. Marsh the other day about this, and I think we came up between 10 and 12 additional sites. Is that right, Chris? Through you, Mr. Chairman.
Yes, Chris, just turn your speaker on, thanks.
Yeah, sorry. I actually sat down and wrote them down. We have 22.
22.
Thank you, Chris.
David, speaker on, buddy.
Thank you, Stephen.
Mm.
Mr. Holmes was just putting aside the lack of inclusion of those sites in the plan. What would you say is your main concern with the rule framework regarding those sites that are included?
Not very much at all, sir. And if you look at our part 1 of our submission, which is the section 42A report,
Yes.
as I say in there, we can basically live with any rules.
Yes.
So in this particular case, I think we just had a story to tell, and it's now been told. We don't have to mention it anymore.
Yes. The reason I asked that is when you gave the case study of the greymouth, I think it was Turangi H at Epiha, as a case study, you said that the ODP rules were not able to protect that land, the operative district plan rules. And I wondered whether that was a historical, I thought it was more recent case study that you're referring to. What's your position on the proposed plan rules in relation to that site? Or is this one of those sites that is not included?
I don't think there's any difference in the rules. You've still got this arbitrary 50 meters around the sites. And in my submission this morning, I suggested we need to look perhaps a bit further than that. And that if we as a hapu go out and we look at an area and we know, everyone knew there was going to be something at Turangi H. We knew it. We'd been to the Environment Court previously to stop people drilling there. The archaeologist knew something was going to be found.
Yes.
We couldn't do anything about it. So if we looked at a landscape rather than a distance, then we could, that's my suggestion, was just looking at landscapes rather than distances.
Yes. Can you just clarify, firstly, whether that is that site is identified in the plan?
Not identified, no.
Okay, so that's the issue. Okay. But even if it was, are you saying that the extent dimension, the metric associated with the area of extent, and then the 50-meter rule that applies in addition, are insufficient?
I think we're talking more now about cultural landscapes, and I've heard the archaeologists talk about this,
Right.
that a site does not exist in isolation. And I think we've probably been guilty of that as well, of just looking at a site. And it's made us go back and look at all our maps and plans, look at our GIS system and say, if we've got 3 sites, what's in the middle? And we've never considered that before. And I think we now need to look at this cultural landscape situation.
Yes. I'll come back to that very soon, the cultural landscape. But in the absence of that, the way I understand the plan working is that sites are identified, either with or without a mapped extent. And whether not mapped, there's a default metric associated with those. And I may need some clarification on that. There may be a further 50-meter buffer off that. I'm not too sure, but that's my rough understanding of how the rules work. And what you're saying is that where 3 or 4 sites are in close proximity to each other, and you apply those spatial areas, there may be areas in the middle that are still important in the gaps between them, but they're not covered. Is that the essence?
Yes, that's the way we see it. And may I say that at one stage, through our discussions with the iwi, we considered removing all the spatial extents from our sites.
Yes.
Because if we did that, then we would have a 200-meter buffer around our sites rather than a 50-meter buffer.
Yes, okay, yep.
Yeah, I was shot down on that one, sir.
Yeah, okay, you've clarified my misunderstanding of the rule there, so thank you for that. Okay, so the alternative to that, in your view, might be this cultural landscape concept. And if you applied that to your Appendix 1, which are the sites of significance within your rohi, that was on your page 6, and we had that map up earlier. Would that mean that large parts, particularly of the northern part of your rohi, would actually be completely covered by a cultural landscape?
Much of it will be.
Yes.
And I
mean,
think this was demonstrated during the energy hearing where we reduced that seismic map,
Yes.
and it's not an exclusion zone, it's an identification zone, watch out, something could be here zone. That's all that was.
Okay. Do you accept that that sort of approach would need to go through a very careful analysis and consideration, and probably, well, it's highly unlikely to be able to be implemented through the scope of these submissions on this plan? It would need a separate first schedule process.
Absolutely.
Yes. Okay. Okay, I'm nearly there, Mr. Chairman. Sorry, Mr. Holswich.
If I can just say that we've had lots of discussions with Dr. Barter, the archaeologist, about this very matter, the cultural landscapes, and he wished to produce a paper talking about this on our area, but there's no money involved, no money around for that now. So
sure.
Yes, there could be large areas, not as no-go zones though, as watch-out zones.
Okay, thank you. Finally, I just want to talk about the unknown sites, but before I do, can you just clarify for me that silent file sites are actually known sites, aren't they?
Correct.
Yes. Okay. So unknown sites aren't silent file.
No.
Good. Thank you. That might seem obvious to you, but I just need to clarify it in my own mind.
Yep.
For the unknown sites, is this concept of the alert layer that you referred to the potential solution that you're referring to?
Yeah, a non-regulatory layer on the district plan, and I think they've got some on there now,
Yes.
flooding zones or something like that. They're non-regulatory, but it's just, if people want to do something, they click on the plan and go, whoa, there could be something here. Let's have a chat with that hapu or the other hapu.
Yes.
And we can come to arrangements, especially regarding earthworks and things like that.
Yes, but outside of the district plan.
Correct. I don't think you can have that within the district plan.
Yeah, you couldn't have a process triggered. You could have an alert layer, but which would trigger a non-regulatory.
Non-regulatory, correct.
Yes. Okay. Thank you for clarifying that. Sorry for the length of the questions.
No, carry on.
No, that's all. But I just
can discuss this all day, sir.
Yeah, these two divisions of known and unknown sites are I think are central to all the submissions that have been received on the plan. So I just wanted to test them with you in the first instance. And that completes my questions. Thank you, Stephen.
Yeah, thank you, David. As always, quite sort of precise and great questions, both Antoine and David. Really good. Keith, and Chris, I have just a few sort of follow-up questions. The first is sort of around your comments on page 8 of your updated statement, Keith, and it's around this listing of mana whenua or relevant mana whenua in the Schedule 3. So there is a column there, and as Antoine said, from a practitioner point of view, it's always great to know, perhaps if you're thinking about an idea, who to pick up the phone to, just as a starting point. And so I think there's real value in that type of notification in the plan. Is it possible that there may be some sites that are taonga, sites of special significance to more than one hapu?
I've always been raised through my kaumātua that there is one mana whenua group that over a particular area, there could be lots of associations, but there is only one mana whenua group. And I think Mr. Coffin, Commissioner Coffin, may understand that concept. We have sites outside of our area, our rohe, but we don't claim mana whenua status over that. It's in the rohe of somebody else, but we have an association with that site. And it would be unwise of us to put us as mana whenua on those sites outside our rohi.
Mm.
That's just our view and my view. Mrs. Marsh may have some other comment on that.
No, and this is why it's so important to us that we do hear expert evidence from people like yourselves who, you know, you hold that mana in our process. So I just wanted to follow on with a question on this, and this is something that, again, Sarah Mako and certainly Lauren Wallace, who's listening in, would quite like some advice on. I think, as many of you know, I sat as the first instance hearing commissioner on the Mount Messenger bypass designations and resource consents, 2018. And there was, through that process, let's just call it competition around mana whenua claims. And I'd always been sort of trained as a decision maker that it wasn't for a Pākehā white boy boomer from Hawke's Bay to make a call on who was mana whenua or not. Certainly if there was evidence of association and thinking about who might be involved in things like kaitiaki groups that are monitoring work, those sort of things. But on appeal, Judge, just trying to think, the judge based in Marlborough, who chaired that, his name will come to me, someone might be able to remind me. He set up a panel including another Environment Court judge, a Maori Land Court judge, and two quite experienced commissioners. And in that Environment Court decision and subsequent sort of High Court proceedings, the Environment Court said yes, where there's clear evidence of mana whenua status, and my reading was referring back to, you know, treaty settlements and claims over defined rohi. That was something as decision makers we should be looking at. So certainly that recent case, I think, is quite relevant. It's a Taranaki case, and Lauren, I think you're listening in, and Sarah, if you could get both, or if you could both get Maya and Lauren to address us on this matter, because I think that is a key issue of potential contention and that we'll be hearing from different groups of mana whenua. So yes, does anyone have the name of our Environment Court judge at your fingertips? David, he's a judge at X, all around Wellington. He's based in Picton, I think. Well, Lauren, you might know.
Good morning, Commissioner. Sorry, I was just on a phone call, so I may have just missed some of this
Okay.
conversation. My apologies. Perhaps you're talking about Judge Dwyer?
Judge Dwyer, yes.
Yeah.
Yes. And this is about, the question we're talking about is that there's a list in Schedule 3 of who the mana whenua entity is in relation to each site.
Yes.
And there is some contest on that between some of the submitters.
Yes.
And I wanted both yourself and Maya to look back at those series of cases around Mount Messenger.
Yes.
Where Judge Dwyer compiled a 5-member panel, including Maori Land Court judge, another Environment Court judge, and 2 commissioners, who really did turn their mind to decision makers and their obligations or not to determine mana whenua status.
Right.
Yes.
Mount Messenger was perhaps the Environment Court case. Okay, and then
Yes.
just describe.
And there's a series of High Court cases.
Yes.
There's a whole body of litigation.
Yes.
It's still ongoing.
Yes.
So yes, we've been asked by some hapu to include sites and names on Schedule 3 that aren't currently there, and so it's a key issue for us. I think would appreciate some advice on.
Understand. Thanks, Commissioner. Apologies for not having heard that for the first time around.
That's all right. All right, so we'll just carry on, Keith. I think just to follow up from David's question about the amount of work which you've recognised, and I think we all recognise what a very large body of work this is. And like the planning process, we all know it's iterative, goes on, and we did hear very clearly, because I asked specific questions about this of the council team, that they do have a program to carry on with this work and to bring forward further plan changes as part of just continual improvement or continual updating in this sphere. And also certainly from the witnesses we've heard, just thinking through the topic of cultural landscapes and how that concept may or may not be able to be, excuse me. Sorry, I'm just about to sneeze, and I have a very loud sneeze. It used to scare my children when they were little, so you wouldn't want to hear it. It's gone away. Yeah, so Keith, just were you listening in when we were asking those questions, and that this go forward plan, which clearly you think has been too slow recently, there seems to be from my listening anyway, that the council's been working pretty hard as a team, and there's a big commitment to continue this body of work. Are you satisfied with that, or is there something else you'd like to comment on?
So we can't change what is in the plan at the moment. So we've got to be involved with the additional sites at the next plan change. We want to be involved. We're happy to work with council as long as they're happy to work with us and get us involved as well. So I think the next stage is to sit down with council and say, right, we've got all these extra sites, what do we do? And that's a discussion to have after this plan goes through.
Yes, and your submission currently doesn't have those sites. They're not on the table for us to add.
No, we offered those to council in our original submission. We said to council, we can either supply you with those sites now, or we can sit down with you and go over those sites for you to do what you need to do. We got no response.
Okay, so they aren't in your original submission on the plan?
No, they're not. They're not in our original submission, but we offered to give those to council.
Okay, so it's part of an ongoing process, and we can certainly make some commentary in our recommendations to council about perhaps looking, Antoine will be writing this, just in terms of support for that general concept that so it's a long journey, we're partway through, and we'd encourage the parties to continue. Antoine, do you have any?
Yeah, well, I haven't seen the sites, but on the face of it, it seems like a number of sites that could be easily accommodated through a future plan change with other sites. And we did receive some evidence from the council. I think it was the slides that we saw, particularly there was a PowerPoint slide that showed the progress of the different iwi and hapu and their progressing of their SASMs. And I think, yeah, any future plan change would accommodate those, I would have thought, reasonably easily, but particularly in regards to Ngāti Rahiri's experience that they have in doing this type of work. And certainly from plan change 43, if that work is anything to go by, it will be of a very high standard. So that seems rather straightforward to me. But those, I don't want to. I've said it, but often you say these things are straightforward, and they don't end up being as straightforward as you think they are. So I'm just qualifying that as well. It appears on the face of it to be rather straightforward exercise.
Yeah. And we'll certainly hear back from Joe and the team at the council on the right reply on the go forward plan. Look, a couple of other quick questions. Keith, I think you were in the room when I discussed this issue of a protocol around silent files, and I certainly sort of listened very carefully to Mr. McCurdy saying he was feeling a bit nervous about holding this tonga on his computer of the sites. And would you support that it would need to be a pan iwi agreement, I think, in terms of how council deals with some of these sites in relation to Lagoina requests and things like that. Would you support such a process?
And what process would that be, sir? What was I missed the point there?
So we did talk with a number of the council and a number of other parties about that. Currently, if council has information, whether it's on Mr. McCurdy's computer or it's on their computer, there's certain legal obligations to disclose that information, and particularly around the silent file issue. I felt, and I gave a view that if council could perhaps come to some sort of protocol around those disclosure obligations they have as a local authority, that was probably something worth advancing with some priority. But I'm just interested in your view on that.
So any information we give to council now, we're quite happy for that to go out, because we don't give council information that we're concerned about. That's just what we've done, because we know that up until now, council haven't necessarily looked after that information. So the extents of our sites, the names of our sites and what they are, we're quite happy for council to give that to other people, not to sell it or anything like that. But it's nothing different. If it's in the district plan or council give it to somebody, there's no difference in that information.
Okay, I'll be interested in looking at your contract, just because that's, contracts have obligations, agreements in them, so that will bring us back. Look, I do have another couple of quick questions, really about your page 5 of your evidence around the site at Epihara Road that's currently being investigated, the Turinga H well site at Motunui. Just with your experience around the traps, Keith, my understanding is that exploration, and this will go to your issue about the depths of the earth and the heights of the heavens, directional drilling technology is around to explore resources under the ground from quite a long way away. I'm quite knowledgeable through my geothermal experience with those sorts of things. There's one thing about disturbing the surface of the site and destroying that. There's another, I suppose, resource issue around looking for resources, whatever they might be, sort of underneath sites. I've taken that you're concerned, particularly around Urupā, of any disturbance underground, but is there a difference, say, around Kāinga or other areas with drilling or investigating under, say, a wider cultural landscape through directional drilling?
I'm just waiting for Mrs. Marsh to look at me here, sir, when I speak on this, but I think it's a site-by-site basis. If you've got a Kāinga site that was a garden, for example, I have no issue personally with that. Mrs. Marsh may differ. An Urupā, yes. A sacred pa site, even, yes. Some sites, yes, some no. I don't think you can actually put a definitive thing saying yes or no, but I'd like Mrs. Marsh to come in on this as well, if I can.
I have to agree with you, and that's saying something. Site by site, there is no way that you drill underneath an Urupā or something that is excessively sacred or the stories that we know as a hapu. Papakaianga, once again, what was it used for? What was the reason it was built? You need to go back and look at the stories and to really say yes or no. It's really hard to give you an answer on that one, because we could say yes to a Papakaianga because it was just built because Auntie needed a new whare. But can we go back and look at another one where it was built for a kaumata or for his last resting place? Then that has another complete bearing on it. So yeah, site by site. once again, we could still do that within the system and state, give it a number point. 1, forget it, there's just no way, down to 3 or 4. So yes, you could.
Okay. No, both your answers are helpful, because that's your position, which is appreciated. One last question, Keith, and it's around again your paragraph 13, page 5, and it's where you're talking about third parties. In these sort of processes, there are at least 3 parties. There's an applicant. If we're talking about resource consents, there's the council, and there's a hapu or iwi. Are you and normally a landowner too? So, what are you referring to in terms of third parties in this context? I take it as neighbours and maybe anyone else apart from those four parties that I've highlighted.
That's correct, sir. I base this on my many years as a land surveyor having to deal with affected parties. If we want to do something on our land, there are 2 parties, us and council. We don't want, if it's a restricted discretionary activity, it flags the affected party, and then council go out to neighbours. We don't want neighbours involved.
Okay, so that's clarified. So it's on your own land. It's on your reserve
Correct.
land. No, that's a good clarification. Thank you for that. And look, we will move to your next section, and just take us through your part 1 now, Keith. That's good.
Thank you very much. Part 1 of our submission is what we call where we are going submission. Very, very brief. As mentioned previously, our first concerns are the references to Schedule 3 throughout the office's recommendations. Now, as Schedule 3 is incomplete and we can't accept it at this time, we're concerned about how this chapter of the plan can be implemented with references to the incomplete Schedule 3. It appears a workaround for this is that the chapter can be agreed subject to a future Schedule 3, but in saying that, clear and precise directions must be implemented to ensure there is full consultation and agreement with us. And as an aside from that, and as a surveyor in my previous life, there is no certainty if the district plan refers to Schedule 3 and Schedule 3 is wrong or incomplete, how can that work? So we just raise that for your attention. In our paragraph 19 objectives, we can live with these objectives, but we note as before that external consenting authorities can circumvent the whole council process, and we understand that that can't be dealt with here. We don't have a solution of getting rid of Heritage New Zealand. Sorry, Councillor Commissioner Coffin, but they're in the picture. In paragraph 20, we talk about the policies, and we consider that the majority of the policies could be workable. But we note that there were many, many changes. And although they seem to be saying the same thing, it is a bit confusing to us. We can accept them though. We note policy P2 that has the best intent for us, but we once again refer to external consent authority that can override this policy. Don't know how to sort that out, sir. We note there are many policies that will conflict with what we as tangata whenua may wish to do on our own reserved lands. And this is the restricted discretionary matters. And we ask how this can be addressed. And it appears that it can be sorted either by a new policy that allows us to do what we like on our own lands as a permitted activity, or the Maori purpose zone chapter allows us to do what we like on our own lands. We would prefer this to be dealt with in the Maori purpose zone, but the land is not yet zoned Maori purpose zone, it's still rural land. So we've got to have a bob each way on this. We've got to deal with the rural rules at this time, hoping we can get Maori purpose. But either way, we would like to be able to do what we like within reason on our own lands. In paragraph 21, we talk about the rules, and we're always concerned about allowing as a permitted activity any earthworks, including gardening, or on or within the extents of our identified sites. Such gardening activities, and I've got gardening in inverted commas, and that includes ploughing, tilling of the land, will aid the destruction of our sites. And any such activity should be considered discretionary. And sir, we need to go no further here than the sites we could not include in Plan Change 43 because there was no visible archaeological evidence. Quite clearly, because such evidence had been ploughed out over the years. And we mention this despite the comments from Ms. Walker of Federated Farmers that cultivations and ploughing do not damage sites. We have the evidence that they do, and quite obviously they do. In paragraph 22, we talk about that this leads us to our earthwork submission, where we express concern about any permitted earthworks within 50 metres or more of any site. And we've previously discussed that with you. In summary, sir, the objects, policies and rules, we can generally live with and work around anything that is finally decided on. The problems we've had in the past is council themselves not adhering to these matters and issuing consents that are clearly inappropriate. We also note that any council follow-up to any consent granted is by far in the majority non-existent. This is widely known in the development community and is often taken advantage of. And this matter has previously been touched upon by Mr. Nucky, where he talked about a house that had been put on a site, and Ms. Benson regarding cell phone towers in their submissions. Council should and must carry out follow-up site visits to ensure consent conditions are being complied with. And I note here that we most certainly do not want to head back to the Environment Court again, because council has unilaterally changed consent conditions on development projects to our detriment. And I say that such a situation is ridiculous beyond words, but it did happen. Council chose unilaterally to change consent conditions that had been decided in the Environment Court. In our conclusion and recommendations, we say that that's our submission. We once again express our heartfelt disappointment over the way council refused to consult with us over this additional site identification matter. We ask that the concerns and recommendations we have raised on this matter may be considered, and where appropriate, mitigation be provided. And off topic a bit, sir, and here we once again raise a matter previously discussed about the vertical extents of our sites of significance. And I think that you are seeking advice on that. And that's it, Mr. Chairman. Commissioners, thank you very much for taking the time to listen to our rather long presentation. And of course, we're happy to take any further questions. We look forward to participating in this plan process matter in the future. And once again, we acknowledge you all and thank you very much for your time. Tēnā koutou katoa. Thank you very much.
Thank you very much, Keith. We'll move to questions now from Commissioner Coffin.
Hey, thank you very much. I didn't have many questions, more probably because we've covered some of this ground before, but maybe just further clarifications. Just on the gardening issue, and I think it's fair to say, not only from our site visits, but also from evidence we've received from Mr. McMurdy and others, that there has been historic ploughing of sites of significance which has damaged them, certainly from an archaeological point of view. There's been physical damage to those sites. And I just but it was put to us by federated farmers that those techniques and ways of gardening of the past are no longer prevalent or present now. And I just wondered if you could respond. You said you know of examples where ploughing is damaging sites. I'm just wanting you to just expound a little bit more on that, like in the present day.
Not in the present day, but the sites that we looked at in Plan Change 43, when we visited the areas, there was no archaeological evidence because of the ploughing.
Yes,
and it's the ploughing that causes more damage than anything else. By continually turning over the soil, any features that once existed are gone. We don't have any current examples of that, Commissioner.
Thank you.
Mrs. Marsh might know of some, but I don't know of any.
And Mr. McMahon might have some further questions on this particular subject. And I just wanted to clarify that in terms of managing sites and areas of significance to Māori within Māori purpose zones, you're wanting the zone rules to effectively manage that, or the objectives, policies and rules to manage the SASMs, rather than the SASMs chapter dealing specifically with those matters related to the Māori purpose zone. Is that, did I hear that correctly? That's what I heard, but I just wanted to
yes.
No,
we would prefer it dealt in the Maori purpose zone coverage, because if we want to build a marae within 15 metres of our urupa, because that is what we do, we should be able to do that. We don't, and it comes, people can't understand that. It's something that we are comfortable with. We're not comfortable with Joe Bloggs building a house within 15 metres in urupa. We're not happy with people disturbing the land within 50 metres of an urupa, but to us, building a marae works.
Yes.
It's a difficult concept. So yes, we would rather it be dealt with in the Maori purpose zone.
That's probably a really good example. So I just appreciate that. That makes sense from the example that you're given, where an appropriate development may occur within the 50-metre buffer zone. So thanks for that example. Just my last question is just around your concern for no monitoring of consent conditions, and this might be just perhaps a question that can come back in our right of reply from Ms. Ritchie, just around what's the current processes for monitoring consent conditions, where they're affecting sites and areas of significance to Māori. So that perhaps is a question for Ms. Ritchie in the right of reply, rather than yourself, Mr. Holswich.
Thank you. If I can just mention that I can't recall council ever looking at any sites, and Mrs. Marsh, I see her shaking her head as well. And all of the development areas that we've been involved with, we can't recall council ever coming out to a site, well, they certainly haven't let us know, about checking the consent conditions. And that's something that they need to do. That's our point on that one.
Yeah, we'll get some clarification on what's the current process, but that was all my questions, Mr. Chair.
Thank you, David.
Yes, thank you, Antoine. You've anticipated my question, and I guess that goes with our role as Zoom buddies, so thank you for that. I did have actually a question on the Maori purpose zone, Mr. Holsworth, as Antoine indicated, and that was really, it was a matter of scope, and I just wanted you to remind me whether the original submission lodged back in when the plan was notified actually sought that relief, that the Maori purpose zones cover those sites that you referred to, as opposed to relying on the SASM chapter.
I don't believe it does. We were involved right at the start with the implementation of the Maori purpose zone. Stood up, leapt up with joy, clapped our hands and says, wonderful.
Yes.
We're just trying to figure out what is the best way of getting around this restricted discretionary activity of us building on the land.
Yes.
So I suspect you're quite right. We're probably out of scope.
Okay.
How it's dealt with, I don't know.
No, I remember the questions that we put to you on this in the energy and as the substance chapter, and you showed us actually you showed us a number of appendices that were actually similar to the ones that are in this. So, and particularly the buffer zone diagram, which was your appendix That was on page 14 of your submission anyway. So I recall that. Okay, no, thank you for clarifying that scope issue. That was all from me, Mr. Holsworth. Thank you, Stephen.
Thank you very much, David. And thank you, Keith and Chris. You've managed to do quite well in terms of going back and forth between yourselves with body language on the Zoom. It's not easy. And Chris, thank you particularly for coming and supporting Keith. I know you're doing a lot of work on the ground, and you've got a current site you're focusing on. So all the best with that.
Thank you.
Yes. So look, I think, Glenn has been waiting patiently for a long time. I'm just sensing that we should probably have a 5-minute convenience stop, going for an hour and a half, and we'll pop back at 11:40 and start with. Yes, kia ora, Glenn. As I said, you've been waiting patiently, and I really do acknowledge your attendance today and on the other days. So maybe if you could just kick off.
Sorry, Commissioner, I'm not sure whether Commissioner McMahon's online yet.
Okay.
We're good to go.
Yes, so over to you, Glenn. I think you have 2 parts to your submission. All good?
Can you hear us, Glenn?
Sorry.
Yes, Glenn, so welcome. I think you have 2 parts to your evidence, and if you perhaps would like to take us through part 1, and then we'll pause and make the arrangements for part 2.
Yes, thank you. Tēnā koutou katoa. Yeah, well, actually, there was, I take it as being read, and there were a couple of things that I wanted to hit on, but Keith actually pretty much went over almost all of the points that I had intended to do. So anyway, in part A, our main concern was to raise the, as well as what Keith has just done, the issue of landscape and potential landscape scale protection. That our sites are not they're not just lone sites, outliers, that they are part of a landscape, and that we have many multiple sites within our rohe that are connected as either just multiple kāinga on, but you've got, for instance, the other week we had the Roe whānau talking about their property, which is on Orapūriri. The rise of Orapūriri is only one end of a much longer rise, and there's another kāinga at the other end of that rise called Hoiwaka. But the main road now goes directly through the middle, and in all intents and purposes, that they're considered 2 sites, but they are one continuous site. with two known areas of features. And so and of course, as Keith mentioned as well, you know, the other bits that go in between these things, because essentially what we tend to have is past sites are areas that are still left with earthworks that are easily visible. But of course, our tupuna never lived just on those areas. So in many cases, they were often just retreat sites. The kāinga was actually out further. The mara, all of the different mahinga kai, the different food gathering areas and cultivation areas are all out on the landscape, and they're not covered under the kind of you know, they're not considered, I suppose, as significance. But of course, for us, they are. And I know you guys have come to look at, you know, you came and visited, you came to Te Rewarewa. I think you also came up to Tārereare, up to the marae kātere, ki te moana. So you'll understand that, at least for us anyway, we are in the growth area of New Plymouth, and not, you know, it's conceivable within a couple of decades we will be, you know, that it will be a continuous built area between New Plymouth now and Bell Block. So as a child, Bell Block was a pretty independent community, but it's almost already one continuous built space, and it's only going to get worse. So we're under incredible pressure. We also house, along with Puketapu coming from our other side, the industrial zone. But it's conceivable where we are is in a generation or two will be almost the centre of New Plymouth. The main industry and the main utilities of the council are situated within our area as well. So the water intake, as well as the waste treatment plant, as well as the refuse facilities, are all situated within our area, just in our backyard. So infrastructurally wise, you know, we're in the middle of we're kind of ground zero for the growth of New Plymouth. So the first part, I suppose the highlight that I'd like to make from the first part is around the reserves, former reserves, native reserves. So we have some significant areas within Aotearoa that we've set aside as native reserves that do not fit under the SASM, sites and areas of significance. They are sites of significance for us, along with many sites of significance, I suppose, of mahinga kai and other areas of usage that we actually use today. Some of them are modern equivalents, I suppose, of those of mahinga kai, of what would have been an entire series of ecosystems. And so we have, you know, at one time there would have been many areas that we could have gone to, but those have been reduced. And so the ones that we have left, the few that we have left, become even more significant because they are the only few ways that we can maintain some of those cultural practices. But those cultural practices are not really able to be, you know, that they're not able to be recognised, I suppose, with this particular tool that the council has. Yeah, I think for A, it's I mean, apart from the obvious, the inclusion of some new sites and or changing of names. That's probably, I think Keith is kind of, in regards to the idea of landscape, Keith has kind of beat me to it today. Yeah. So I just take it as, you know, that those things have been raised with you, and I'm happy to move on to some of the potential issues we want to raise around B, the second part of our submission.
Thank you, Glenn.
Yeah.
Let's just pause there and we'll see whether commissioners have any questions on your part A.
Hey, thanks, Mr. Chair. Tēnā koe, Glenn. I just had, perhaps it's two questions to start, and I think we'll have some further questions in your second part. Just in regards to cultural landscape considerations, and I thought the example you gave was a good one, where you've got two features, but they're part of that landscape. And I just wondered, for the purposes of a plan, which is, I suppose in many ways, it's almost like if you could think of, there's mountain peaks and you've identified the peaks, but you haven't necessarily identified the bases or the valleys or the spaces in between. What would be, did you have any views around how landscape is managed? And this is, I suppose, it's a little bit hypothetical, because at the moment, this plan, like a number of other plans around the country, are indicating or intimating that cultural landscape is an area that the plan is going to go into at a later stage. It hasn't developed a sophisticated or comprehensive way of managing cultural landscapes yet, but just casting yourself into the future, what might that look like from your perspective?
I think it's a hard one, but firstly, I think we need to recognise that the modern development destroys cultural landscape. There's no two ways about it. There will be areas, for instance, within Val Block, which is still within Aotearoa, that were developed in the 50s, 60s, 70s, where those features are still under those houses. But in a modern, since the, I don't know, let's say maybe late 80s, definitely 90s and through to modern, the very first thing to roll into a site is a digger. And from that point on, it's a seek, quantify and destroy. I suppose I'd like to go through more of this, I suppose, question in the next part, in the closed area. But essentially, we also need to protect these areas because they're not being, once they're gone, they're gone. And there needs to be some kind of ability to place aside these areas. As I listen to some of the other groups, particularly some of the more outlying hapu, they have time on their hands. The farmers are still wanting to farm, and so there's as long as they understand the current practices. For us, with the growth of New Plymouth, we know that any development invariably is the development that's going to destroy. And is the only really mechanism that we have is to protect sites in order to keep them, looking something similar to what they currently do, because of course they're already, many of them are already compromised as well. So they've been ploughed over. They've had 170 years of other activity. So they're already compromised. But I suppose what we still have the ability to do is to allow them to add context to the sites that we that are identified. Yeah, context is everything. All of those little microclimates and all the different strata and different ways that our tupuna used the area and lived and thrived. It's really important because that's telling our story.
But just this is in the hypothetical. I've seen some councils and tangata whenua working together where they identify cultural landscapes, including sites of significance, which may be protected in the district plan, and that helps inform the way in which development occurs, where it occurs, the extent to which it occurs, and also incorporating aspects of the landscape, both natural and cultural. So it isn't necessarily about protection in its purest sense, but it's about recognizing the values of these places, including landscapes, and the way in which development can respond to those in appropriate ways. Is that something that you would support or would consider in the future?
I think it's the only way. I think co-designing these spaces is the only way forward. I mean, because the question is the question to me is pretty obvious. Sites and areas of significance for who? For Maori. So we're the ones who need to be, it's we are tangata whenua, but we're not on the whenua anymore. We've been removed. So what's the ultimate gain? What's the ultimate outcome? Is to return tangata to whenua. And if the council can help us, well, actually the council has a responsibility to help us because they were part of the mechanism to remove us.
Thank you. My next one is a very specific question. You've requested that the hapu be included in the mana whenua to a number of sites. Okay. It's in your submission, or in the submission you've provided to us. And you would have heard Mr. Holswich saying he was very concerned. Your sites don't affect Ngāti Rahiri, of course, but he was wanting that there to be a process by where there might be an addition of hapu to the mana whenua list in the plan. There's a process, and he outlined his ideal of having a hui. The outcome of that hui is passed on to council. Did you have any views in that regard?
Yeah, I think it's an interesting one. We have, I mean, it may be considered that we are going over our outside of our area. It's all about history. It's all about context, right? And I think I think only we can answer that question. I think Keith said the same thing, and that it's what am I trying to say? It's for us to that is ngā hapu, ngā whānau, to come to a conclusion as to who sits where. I think that there are many there are many examples where there are legitimately multiple what are now modern hapu. But for instance, some of the sites that we've placed our name on prior to our two hapu being called what we are, the genesis of both of our hapu start from that place. And so that's why we are saying we have something to say about that place as well. Our tupuna are buried at that place. But we need to come to terms with within our own processes as to who gets to speak about what. It's not a problem, I believe, in most cases, because we're all thinking we're thinking similar lines. But I think the example was raised before about Mount Messenger, where two entities were taking polar opposite views, and that of course is when it's a problem. And it's in our current thinking, the more the merrier. It's not a threat to us that another hapu might want other whānau. We understand our what we're trying to achieve, and we can articulate that. And but I also think that it's all the different hapa are at different stages, and so and we all have different focuses. So we just need a very simple guideline. But I think that currently there's not the ability to distinguish. So when you register against a site, you are registering as mana whenua, or as a party of interest, and they are treated the same in the process. For instance, we want to be put on those sites that we've listed in here, but we don't expect to be stepping over mana whenua. We just want to understand that we have something to say about it. But that's our stance. There could be, and that's our, that's our expectation for other hapa as well. So that's how we would do it. But yeah, leave it for that.
I appreciate that. That was good. Thank you. No more questions, Mr. Chair, at this stage.
Thank you, David.
Yes, thank you, Stephen. Glenn, I've just got one question for you, but it's quite a delicate one, and I think it goes to the nub of the issue. So please excuse me if I'm a little bit clumsy in expressing it. But it comes from something you've just said a few moments ago, and I've written it down. And you say you referred to the title of this topic being Sites of Significance to Maori, and you posed, well, who is that? And that's really of sites of significance to tangata whenua. And I understand that. Then you went on to say that, well, the issue is that, iwi is no longer always on the whenua, but there are still strong associations with that whenua, either direct or associated. And that's come through very clearly to me. I'm also hearing from landowners of land that are subject to sites or subjects to extents associated with sites, who are now the landowners of the whenua, if you like, and they obviously have certain expectations in place that reflect the zoning of the land, whether it's rural land in terms of traditional agricultural practices, or whether it's the growth land that you referred to. And clearly the Bell Block area is under a tremendous pressure, and identified growth areas, area Q and R, and the industrial zoning that you referred to. So I guess my question to you is, like, seeing those two sides of the coin, what do you say to the landowners of the whenua now, who perceive a uncertainty as to whether they can continue their existing land practices or undertake any future land practices in accordance with the zoning, who see the process and the outcomes as being perhaps possibly uncertain, particularly in relation not so much to the identification of sites, but in relation to the identification of extents associated with sites, either the defined ones or the undefined extents. What would your advice be to those parties?
I have a lot of aroha for them. I mean, I was, as I listened to the road farmer, for instance, I felt very sorry for them, being caught between a rock and a hard place. As we have been for many generations, and through no fault of either party in this case, right? So I think that it's a huge conversation. The council has to, at the end of the day, these are legislations and that have impacts upon people, and when the council or when the Crown creates legislation, they need to be ready to compensate people who are disadvantaged.
Yes.
I see, if it was me, I see three clear areas of ways that this could have been resolved, or this could be resolved, but none of them are easy. The first area would have been for instance, had Te Aotearoa in its treaty claim received full compensation. The row whānau, we could have said, well, you're a willing seller, and we're willing buyer, and we received full compensation. Transaction, bam, done. That didn't happen. We only received a tiny fraction of that. So that's not possible. The other one would be, this is a similar situation in my mind to what happened with the West Coast lease, where the Crown changed the legislation and the farmers went to court and got a compensation package. And I don't think that that's going to happen. I don't think there's enough of this happening, perhaps, to warrant, the level of I don't know, energy that's going to be required. But I think the third and most obvious one for me is a co-design process where we sit, where Hapu and council sit and co-design a solution.
Yes. And is that a that third solution, is that a does that sit within the district plan or outside the district plan?
Unsure. It seems like to me, it seems that when you try and put something into a plan, that that's a long process. But you are creating precedents, and so it's that's over my head, I'm afraid. But something needs to happen. It's as simple as that. Something needs to happen.
Yes. One of the if I can just share an analogy with you that we discussed earlier in this week at another hearing, and that was about development in the central city of New Plymouth and the need for vibrancy. And there's a number of regulatory and non-regulatory ways that can occur. One of the regulatory ways is, I guess, controlling leakage out of the central city into some of the outer centres and into the industrial zone or the mixed use zone, so that the central city stays vibrant. And we discussed how that might be able to occur. And I floated the concept of maybe, in addition to having permissive rules, there might need to be some form of notification incentive that underpins a design-led approach, where developers have the certainty of process, that if they come up with a good design and they discuss it with the council, that they'll get there in the end, but there's no pressure from third-party involvement. And I guess what I'm hearing from non-iwi submitters is that they're very apprehensive about the process of consulting with iwi. And there's not a criticism of iwi at all. This is just relaying what I'm hearing, because it creates an uncertainty of process, and with that comes an uncertainty of outcome. And we heard from a couple of submitters, one in particular based in Japan, who owns land, perhaps in Eurohi, I'm not too sure.
Yeah.
Mr. Rowath,
That's the whenua,
who said that he has no appetite to carry on the ownership of the land, but potential owners also, once they do their due diligence, have no appetite either to purchase the land, because they are uncertain as to the process and uncertain as to the outcome for its own purpose anyway. And so I'm just wondering, I don't know what the solution is. I mean, and I'm not asking you for the solution, but I'm just putting that out there, that there is this apprehensiveness created by the process and engagement. And I'm not saying engagement's bad; it's certainly good, but I just don't know what the solution is, and I'm guessing that you're struggling with that also.
Yeah, I think I mean, one of the current solutions, of course, is that we have a seek and destroy type scenario, which is not, doesn't work for us.
Yes,
that's for sure. So so developers who have the money enter into a process and, and effectively can do that. But it costs. There is a significant cost, well, there can be a significant cost. And the more you find, of course, the bigger the cost. It's all, we have no idea what's going to be there. We often know that we're probably going to hit something, but we don't. But I just, for instance, recently, maybe a year and a half ago, we started a process and we ended up finding, 2 grave sites. Unknown, totally unknown, but we knew that there was occupation there, but yeah, and all of that stuff ramps up the level of anxiety. It ramps up the level of participation, and they're all hidden costs.
Yes.
But I think it's a hard one because we're dealing with multiple hapu and multiple iwi with the Nuclear District Council, and we're all at capacity. Some areas, some of us have people who are dedicated, some of us don't.
Yes.
Or at least dedicated and passionate. Keith's a perfect example. He's not only is he does his career, as a surveyor, line up with, but it's also his passion. So of course, amazing submission. It's been a great help for us for Te Atiawa, having some people at Te Atiawa who then help us to filter through the noise to the real point, but it's not always the case. But the key thing about that as well, about having that central kind of touchstone of Te Atiawa, the way that that's kind of working for us is that there's a consistency at least. Because at the very least, if we don't quite understand the process, we should at least have consistency of message, which is not always the case as well.
Yes.
But we're developing these things. This is it's constantly improving. I know that just in the last 10 years, I can see that improvement. The more we used to do everything almost all individually. There's a lot more kind of sharing and replication of process and language and understanding. So I think, but also, I take, for example, what happened at the airport, which was I think a good example of a co-design where the hapu was drove the design process. We're part owners in the design process, and we're able to make real gains in both context and in that idea of returning tangata to whenua.
Yes.
I think that we are maturing. I think that I think with a few more wins over the next few years, I believe that owners and developers will start to see that we have something special to offer that actually adds huge value to the story of our province and of our communities. And I hope that they start to see that they can lean into that space, that they can have that. While we might not know, have certainty around what we're going to find, that we're going to have that the outcomes are going to be more win-wins instead of win-loss.
Yes. Thank you for that. The airport examples is a great success, and we were fortunate enough to visit the airport and get a very nice story about how that process worked from our guide at the time. That was engagement with a corporate, and the sort of landowners that we're hearing from during the course of this are really not corporate or not even developers. I'm thinking of Mr. Rowe, and I'm also thinking of the Houghtons, which Mr. Kiss is representing. Both of them have concerns, not necessarily with site identification, and I don't think sites are the issue. It's the extent associated with sites, and both of them, Mr. Rowe, I've talked about, and the Houghtons have had some issues with the process, and Miss Benson, Marlene Benson, talked about that in an earlier hearing there. I just for those two folk, they see a discrepancy between what the zone permits and the rules of the extent, and those rules generally trigger to some form of discretionary as opposed to a non-complying rule, whereas the non-complying rule is more related to the destruction of the site per se. And I think I asked Ms. Benson about this, but I want to ask you, do you see discretionary activity as a preclusion, or is it about the process working out what's the best outcome on the extent? Is there any sort of premedicated or predetermined outcome in your mind as to that process?
No, well, they can be the same thing, or they can be entirely different. So it's a hard one to answer.
So a range of outcomes.
Yeah, because some discretionary activity can be just as destructive as a developer coming in and just but and then others are not. Are no more than what has already been happened, and it's not going to cause any further degradation. I think, but I think that we're not naive enough to not understand that value, that land value, for instance, is connected to activity, the activity. So just because it's a farm block now doesn't mean that the person who's going to buy it is going to keep it a farm block.
No.
And value of land shows that. So it's actually, it can be worth a lot more just because of potential.
Okay.
Right. And so if I was to look at the row Orapūriri, you could make pretty good assumption that if that property was to be sold and it was to continue to be farmed, that doesn't trigger that. To me, that doesn't trigger any of the council hurdles. That's just carry on. That's probably not the case, though. Probably the people who are walking up and wanting to buy, whether they say it or not, are looking at subdivisions. You'd be silly not to. It's right in the middle of what's going to be the middle of town in a generation. So.
Okay. Thank you for that. As I said, it's the delicate issues, and no easy solution. So I appreciate your thoughts on the matter. Thank you, Glenn. Thank you, Stephen.
Yes, kia ora, Glenn. I've been listening very carefully and just want to thank you very much for your wisdom on this. As David said, these aren't easy planning issues, and I'd just like to acknowledge you and all the other cultural experts that are talking to us as in terms of your area of particular expertise. You'll notice that like all the hearings, we never want to sort of rush through these discussions, because we do get a lot out of the questions and answers, and we're here to hear. So your wise obviously very experienced, advice to us is hugely important. So just want to acknowledge you on that. And also, you know, our visit to Te Rewa Pa was very special for us. We could feel the essence of the place. So just want to thank you and others for obviously having us on your whenua. It helps as well. So I don't have any particular further questions, and we should move to part B of the evidence. And before we do, I just need to go through our order, which we made under minute 21, and I'll just read that out. Our order is that in terms of your evidence, Glenn, it is not to be published on the New Plymouth District Council website or communicated to persons other than the panel members and the MPDC staff reporting on hearing 14, and that the public are excluded from hearing 14 when the evidence is given and the witnesses questioned about that. So that applies to your part B and also that of Julie Healy's. So just in terms of process, I want to pause. We can all see who's in the chat room. The strict interpretation of this is that others apart from yourself and Ms. And Joe Ritchie, who's a reporting officer on this, should not be present. That is as far as that's a strict interpretation, but there are others, including from the council, Araha, Sarah Edwards, and others of your general whānau that you might be comfortable listening in. So just getting your advice, Glenn, on how you'd like to proceed.
Yes, well, Sarah Mako could is actually the two Sarahs. I presume that I can't see if they're both.
So Sarah Edwards, sorry, Sarah Gibson and Sarah Mako
Yep.
are here.
Yep.
So they could stay.
Yep.
Other than that, we'll ask others to leave. And
Unsure. Who were the others? Sorry.
so look, I'll go through it. It's Maria Hokuparo. We have someone called, we'll mention Araha and Sarah Edwards from the council. Rowan Williams, who's from the council as a planner. Sean Zilches, Rangi Maihi, and someone called Michael. I'm not sure who. Perhaps Michael, if you could just acknowledge us with opening up your screen and your video.
Sean's fine. These are all things that I've discussed with them, and they've been supporting me with my thoughts around them, and the two Sarahs.
Okay, all right. So apart from the Julie, who's our administrator, myself, Glenn, you, Antoine, David, Sarah Mako, Sarah Gibson, and Joe Ritchie, if you could all stay on, and if the others could come off. Julia.
So, yep, Commissioner, just before you do that, can I assume that we won't be able to hear from Sarah Mako and Maria Hokupora today? We're going to run out of time.
I think so.
So if people depart rather than me putting them in the waiting room.
Okay. Yes, that's right. We've got a hard stop at 1 o'clock because of other commitments, and we'll have to come back tomorrow and see how we can fit things in. Antoine, you've clearly got another important engagement, so we'll stop at 1 o'clock.
I can go to a little bit after 1. But not much after. Yeah, I don't like them joining up. That's all.
No. Look, I think we would. I think it's important that we do hear. If we have to make some extra time for Joe to give us a right reply, that's fine. I'd rather just take things carefully here. So if others could leave the room, and we'll reconvene tomorrow at 10 o'clock.
Thank you very much.
Thank you, Keith.
So Michael is Michael Keat. I know he was popping out, so I can take him off. Or he's gone.
Okay, and Araha there, she's gone too. All right, this is us. So we're going to just receive your submission on your part B.
Just to be clear, I'll turn the recording off. Is that your expectation?
Yes.
Is it?
Yeah.
Oh, okay.